The 18th and 19th century pirates like Blackbeard and the 19th century German Iron Chancellor Otto von Bismarck preceded the United States in the creation of a social system for the protection of injured workers. The modern workers' compensation system owes parts of its existence to this unique parentage. Pirates, contrary to popular myth, proved to be highly organized and entrepreneurial. Prior to their assignment to the ranks of outlaws, they were considered highly prized allies of the government, plundering and sharing the spoils with governors of the pre-revolutionary colonies, giving them a safe port. Bismarck, the Iron Chancellor, introduced workers' accident insurance in 1881. Phased in between 1881 and 1884, the program became the model for workers' compensation programs in Europe and ultimately America. Bismarck was a pragmatic leader, and his main concerns were the unification and growth of Germany and the protection of his position. On the top of this agenda was the creation of a social program for the protection of workers injured on the job, a workers' compensation program. America did not embrace the workers' compensation social revolution until the 1900s. Maryland in 1902, Massachusetts in 1908, Montana in 1909, and New York in 1910. Each introduced workers' compensation statutes. In 1911, the Kansas legislature first adopted workers' compensation legislation. Workers' compensation laws created a system where injured workers received a set of benefits for work-related injuries in exchange for the workers giving up their common law rights to bring a civil tort action against their employer when their injuries had been caused by the negligence of the employer. Unfortunately, in Kansas, nearly since the onset of the establishment of workers' compensation laws, the Kansas legislature has continuously limited or eroded workers' benefits in favor of pro-employer legislation. Since 1991, significant amendments have been made to the Kansas Workers' Compensation Act, restricting benefits even further. The straw that broke the camel's back, which led to a landmark case of Pardo versus UPS, was when the Kansas legislature mandated the use of the American Medical Association Guides to the Evaluation of Permanent Impairment, 6th edition, in order to decide levels of permanent impairment, therefore affecting workers' compensation values effective January 1st, 2015. Prior to January 1st, 2015, Kansas had mandated the use of the American Medical Association's Guides to the Evaluation of Permanent Impairment, 4th edition. There are significant and major differences between the American Medical Association Guides to the Evaluation of Permanent Impairment, 6th edition and the 4th edition. On March 18, 2015, Francisco Pardo, a longtime employee of UPS, injured his shoulder on the job. Francisco had injured the same shoulder 2 years prior. This injury became the basis of this landmark legal decision in workers' compensation laws that apply in Kansas. On June 1, 2018, the Kansas Court of Appeals ruled in the Pardo versus UPS case regarding the constitutionality of the statute allowing for the use of the American Medical Association Guide 6th edition when determining permanent impairment of function on scheduled injuries with prior impairment. The court found that the part of the statute pertaining to the use of the AMA Guide 6th edition for determining impairment for injuries after January 1st, 2015 to be unconstitutional, since Pardo was prohibited from recovering an award for his permanent partial disability from a new and distinct work-related injury. In this insider-exclusive Justice in America Network TV special, our news team visits with Francisco Pardo, his attorney Keith Mark, Kris Kobach, Kansas's Secretary of State, and Kansas's Republican gubernatorial nominee in Kansas City, Kansas, to discuss this landmark victory for Kansas workers. Here's Kansas Secretary of State Kris Kobach and attorney Keith Mark to share their views on this landmark legal victory.
When the Court of Appeals decision came down in Francisco Pardo's favor, I was relieved. Not surprised, relieved, because the system prior to that decision had gotten so unfair, and specifically with regard to certain injuries where the worker got zero compensation for his permanent impairment, that I felt it was unconstitutional. Francisco had to win this case. The law was on his side. But, sometimes when you go into court and you're convinced that the law is on the side of your client, you still lose. And so I was relieved, absolutely thrilled and relieved when unanimously the Court of Appeals ruled that it was unconstitutional to award Francisco $0 for his permanent impairment. Protecting the worker in the work comp system, in my view, this isn't a Republican or a Democrat issue. It's an issue based on fairness. The worker has to be treated fairly whenever he's injured on the job. And in the work comp system, the worker has traded away his right to sue the employer in return for adequate compensation. Well, when that compensation is zero, then by definition, it's not adequate. People in politics have framed this as an issue where Republicans are always on the side of the employer and Democrats are always on the side of the employee. I don't think that's correct. First of all, I don't think it always is that way. And in this case, where I've been working to try to help workers in Kansas, it's not that way. And I think as a Republican, I want my party to stand up for workers across this country. I think part of the reason that President Trump won the states of Pennsylvania, Michigan, and Wisconsin is because he was saying things that showed that he was willing to stand up for working men and women in America. And so, I'm hopeful that other Republicans will see what I'm doing in Kansas to make sure that workers are treated fairly, and they will recognize that our party should stand up for the worker. And that doesn't mean that the party is somehow turning its back on the employer. On the contrary, if the worker's treated fairly, everybody's better off. The employer has certainty that the work comp system is working. The employees are happy that they are going to be treated fairly just in case something happens and they are injured on the job. Everybody's better off if you have a system that is constitutional, treats people fairly, and everybody, the employer and the employee, feels like they're getting a fair shake.
When I first found out that we won the Pardo case, it was the best feeling that I've ever had in the practice of law. And what was really cool about it is all three of my kids practice law here, and they're dedicated to the same things we are. And I was with two of my boys on the way to a union meeting down in Springfield, and the Pardo decision came in, and it was like I had tears in my eyes. That's the honest to goodness truth, because I knew how much was riding on that decision for my blue-collar workers in Kansas. Kansas workers are better off today than they were yesterday because of the Court of Appeals decision in Pardo. What it means is that we're going to throw out that unconstitutional 6th edition that gives you an inadequate remedy at best and no remedy on some occasion. Now, what we hope is that either the Kansas Supreme Court doesn't take the appeal, which I think there's a chance they will not, or if the Kansas Supreme Court does decide the constitutional challenge, that they will side with two unanimous Court of Appeals panels and say, no, the 6th edition is unconstitutional. 100% of my practice is representing blue-collar, primarily union workers. I like to tell this story to anyone that'll listen. When I first got out of law school, I was working for the largest defense firm in Kansas City. After my dad, who was an IBEW worker, retired, he went out of town with me to try cases. After a successful defense case out of town, I called the insurance company and told them how great a job I did and how the injured worker got nothing. And my dad, he just calmly looked over at me and goes, "Damn, boy, how do you sleep at night?" And really, that's why I have devoted my entire practice to representing blue-collar workers. What I want to tell everyone in the state of Kansas is that when you're at a soccer game for your kids or a basketball game or a church social function, look around, because somebody next to you's probably been hurt on the job. And so if you're a Republican, don't just look over and say, oh, we have to cut work comp benefits. Or if you're a Democrat union worker like I support, oh, we have to give more and more. What we want to do is we want to make work comp fair. And that's why, honestly, as a lifelong Democrat, I couldn't be more pleased that Secretary of State Kris Kobach jumped in as a conservative Republican to help all of us here in the state of Kansas. So what I would say to my fellow Kansans is the right answer is fair, and that's generally somewhere in the middle.
This is the Insider Exclusive, live from Kansas City, Kansas. It is my great privilege to introduce Kris Kobach, the Kansas Secretary of State, and Keith Mark to the show. Welcome to the show, guys.
Thanks.
Thank you.
Tell our audience a little bit about the type of law you practice.
You know, Steve, for the last 25 years, my firm has dedicated itself professionally to representing blue-collar union men and women here in Kansas City, both sides of the state, Missouri and Kansas.
Okay, and you are in the news all the time.
That's correct.
You're running for governor. You're the Republican nominee.
Running for governor at the moment, but my background is as a law professor. I was a professor of constitutional law for approximately 15 years, worked in the Ashcroft Justice Department as counsel to the United States Attorney General, and have worked on a variety of legal topics, most having a constitutional angle, also on immigration law.
Okay. Today we are here talking about a very landmark case, which is the Pardo versus UPS case. And the reason we have both of you on the show, because you are a Republican nominee, and typically, a lot of times, candidates like yourself don't support the worker, but you did in this case, which I admire, by the way. Tell our audience a little bit about this case and who Francisco Pardo is.
You know, Francisco is a UPS worker, been at UPS for many, many years. I'd represented Francisco years back for an opposite shoulder injury, and in this particular case, Francisco got hurt on the job, slipped on oil buildup on a piece of machinery, and when he fell, he grabbed onto a rail, injured his shoulder, tore his rotator cuff, had a labral tear, had some tendonitis in his bicep tendon, and it was a compensable workers' compensation claim. He received treatment, including surgery, was off work for a number of weeks, which in Kansas, the amount of money you get on a weekly basis is capped. So he lost a considerable amount of money while he was off of work. And then lo and behold, when it came time for the courts to figure out what his compensation was for his permanent injuries, it ended up being zero. And the reason it was zero, Steve, is because the Kansas legislature had enacted a law that came into effect January 1 of 2015, putting the AMA 6th edition as the gospel when it comes to figuring out how workers get paid in work comp.
And Kris, what is the difference between what was used before 2015, the 4th edition, and the 6th edition? And tell us why it's not good for the worker.
So the 4th edition, which had been used in Kansas for many years prior to this change that the legislature made, the 4th edition, first of all, gave the worker a more reasonable amount of compensation for his injury, for his permanent impairment for the rest of his life. Francisco was going to be operating with restricted use of his shoulder and his arm. You know, I've had multiple rotator cuff surgeries, and mine aren't as bad as his was, but you know, anyone who's had rotator cuff injuries know that depending on the severity of it, you may not be able to raise your arm above your shoulder. You may not be able to lift any weight with that arm. Anyway, the 4th edition gave a reasonable amount of compensation. So there was some people would quibble whether it was good enough, but at least was a reasonable amount. The 6th edition reduced it down to zero. The other thing that the 6th edition...
For similar injuries, right?
For the same injury. The 4th edition would take that injury, that rotator cuff injury, and give you a reasonable amount of money for your impairment for the rest of your life. The 6th edition said you get nothing. And the other problem with the 6th edition is it didn't allow the doctor to come in and say, well, you know, Keith's got this kind of shoulder injury, Kris has this kind of shoulder injury. They're both injuries to the same shoulder, but, you know, Keith's is more severe. So it didn't allow the doctor to come in and make adjustments for people with slightly different injuries. When the legislature made this change, Keith is the one who first brought it to my attention. And I looked at it and said, wait a minute, you can't get zero and still have due process in this country. The whole theory, the whole basis of workers' compensation is that the worker gives up his right to sue the employer if he's injured on the job, but in return, he gets an adequate substitute remedy that is predictable, and it is probably less than what he might have gotten if he had a lawsuit that went for a really big award in damages. That's the whole basis of the system. The worker trades away his right to sue and gets something that is certain, predictable, and an adequate substitute. Zero is not an adequate substitute. And that's when I said to Keith, hey, there's a due process problem here. There's a constitutional problem. No worker can get zero and still have due process.
And that's exactly what happened here is the judge that heard the case initially said, yes, Francisco has new structural damage. He does have loss of physiological function, but the book mandates a zero. And the judge was almost apologetic in the original decision. He said, based on my mandate to use the 6th edition, I have to give a 0. When we appealed it up to the appeals board, similar thing. They found 0 because the law mandated 0, but in really an unprecedented situation, there was a concurring opinion that said, I agree, the law says 0, but this is unconstitutional.
And that's the Work Comp Appeals Board.
Right.
And then after that, we took the case to the Kansas Court of Appeals.
Now, being a Republican, there are supporters of Republican causes that really aren't in favor of you participating in this decision, right?
You know, it's strange. I think sometimes both Republicans and Democrats will take a position on some issue like workers' comp and say, okay, well, the Republican position should always be for reducing the workers' award, and the Democrat position should always be for increasing the award. And it's much more complicated than that. And, you know, the bottom line is, we have to treat people fairly. And I would hope that Republicans and Democrats would all agree on that and say, look, if you're injured for the rest of your life, the fair thing is to compensate you for that injury. And so I don't see this as a Republican or Democrat thing. Now, I ran into some people who, when they learned I was assisting in this case, they were taken aback that I was helping, you know, people who sort of have a hidebound view of what a Republican should think about things and what a Democrat should think about things. But the bottom line is, this is a country where we have the rule of law, where people are supposed to have due process and they're supposed to be treated fairly. And Francisco was not being treated fairly when he was awarded 0 reward for his permanent impairment for the rest of his life.
And see, what's really funny to me is I'm a lifelong Democrat. And when I hear Kris talking about resistance he got on his side of the fence, I got the exact same type of resistance on the Democrat side. When Kris proposed legislation in early 2015 to fix this, I went to members, Democrats in the Kansas legislature, and I sat down with them and I said, okay, there's this bill. Who's sponsoring the bill? That's Kris Kobach. Oh, I will never support that. But, ma'am, this is a very pro-worker bill. This is to fix a glaring problem. Well, it doesn't matter. If Kris Kobach is for it, I'm against it. And so that's, I'll be honest with you, I really never got actively involved in politics until this issue. And I knew Kris through hunting. But when I brought this problem to Kris, as a lowly union representing work comp attorney on the Democrat side, Kris looked at this and he goes, no, this is wrong, and I will help you. And to his credit, no matter how many people on that side of the fence has, you know, thrown stones at him, he stood in there and he really fixed this problem for us.
Did anybody ever say to you, you shouldn't be on this side of the issue?
Yeah, there were some.
I mean, big money supporters.
Yeah, for sure. They just took the position that, work comp, we just always have to push for lower rewards. But
well, there was something very interesting that I read about this case where the legislature basically said, this is just a small fix. And I think the lower courts looked at it as, well, yeah, it's just a smaller fix, and so we shouldn't be concerned about it. But it was a major fix, wasn't it?
Yeah, here's the interesting thing. So in the bill itself that happened in the legislature in 2013, there were other things going on in that work comp bill. And this was an amendment that was inserted late in the day. And there's no record on in the committee hearing of them discussing this amendment. It's just, and you know, to someone who's not familiar, you say, "Oh, you're changing it from the 4th edition to the 6th edition. Oh, you're just updating it."
Without anybody knowing what the difference was.
No one, the committee members didn't go in and see what's different about the 4th and the 6th. I'll bet that not a single legislator had any idea what change that would have. But an attorney stuck that in there during the committee meetings. The change was made and it was passed into law. And so I don't think the legislature was willfully trying to hurt Kansas workers by making this change. I think an attorney who was working with the drafts stuck it in there, figured no one would notice, and he was right. And now all of a sudden we have a situation where someone like Francisco is gravely injured and gets no compensation for his lifelong impairment.
Now, I will say this. I'll give Kris his deference. The legislature probably didn't know, but I guarantee you those that were sliding this in, they knew. And they knew exactly what it was going to happen.
A very small number, but the vast majority of the legislature had no idea what was going on.
Well, you and I both know most people don't read all the legislation, right? We see that in Congress.
You see it all the time. Legislators pass things. Someone tells them, yeah, you're going to vote yes for that, or they maybe read a one-page summary, but they don't read the whole bill.
Or Nancy Pelosi, let's pass it and then read it.
We'll read it afterward.
Yeah, a lot of politicians like that, right?
What a shame.
What does this mean for the workers in Kansas?
What this issue means for the workers of Kansas is that if this case does not, if this decision does not stand in the Kansas Court of Appeals, right now it's being appealed from the Kansas Court of Appeals, where Pardo won, to the Kansas Supreme Court.
It's being appealed by the Attorney General, right?
So the Attorney General intervened in a companion case and then appealed that companion case to the Kansas Supreme Court. And then the employer in that case is arguing consistently with the Attorney General. So it's a little bit complicated. There's an intervener and then an appeal, and it's a case that's virtually identical to this one. So I'll just put it this way. The issue now stands in front of the Kansas Supreme Court. If the Kansas Supreme Court goes the wrong way and effectively overturns the victory that Francisco Pardo got in the Kansas Court of Appeals, then Kansas workers all across the state will be in a situation where they could get zero amount of reward or award for their permanent impairment, whatever the injury may be. There are multiple ones that come down to zero, which is unconstitutional. If the decision stands and the victory that Francisco won at the Court of Appeals is effectively sustained by the Kansas Supreme Court, then Kansas workers will be saved in the sense that they will still have adequate compensation if they get injured on the job for these types of injuries.
Do you think the decision, if the Kansas Supreme Court upholds the appellate decision, do you think that forever the Kansas legislature can never go back to using the 6th edition?
You know, it'll all depend on how the Kansas Supreme Court writes the opinion. If they write the opinion in crystal clear terms and say, look, the 6th edition is unconstitutional, and any table of injuries in the future that reduces someone's award or compensation down to zero is unconstitutional, yes, then it will be prevented. The legislature will never be able to make this mistake again. But again, it all depends on how the court writes its decision.
And I'll say this, Steve. So giving Kris deference on that they didn't really know what they were doing the first go-round, if the legislature comes back and says, oh, no, we want the 6th, then they don't get a pass. Then they will have done wrong, knowing it's wrong to their fellow man.
I understand that we have Francisco with us today, so let's bring him on. It is my great pleasure to introduce Francisco Pardo to the show. Welcome to the show, Francisco.
Thank you very much.
Thanks for being here.
Good to be here.
You've gone through a lot, right?
Yes, I have.
When you injured yourself before at UPS, you got compensation, some sort of disability, correct?
In the first one, yes.
And then when you injured yourself again, the second time you found out you weren't going to get any money at all.
That is
What do you think about that?
I didn't think that was right, you know, on my behalf.
What did your fellow workers think about it?
They also thought it wasn't right either. If a person gets hurt on the job, you got to be compensated for your injuries.
Right. And how did you end up at Keith's office here?
Fellow workers at Local 41 said you need to call Keith Marks, and he'll help you out.
What is your feeling about the entire justice system now as you've seen it over the, what's it been, Keith, 2 years?
Yeah, since early 15.
What do you think about the legal process?
At the beginning, when I first found out about it, I didn't think, you know, on my behalf, for the fellow Kansas workers, people that work in the state of Kansas, I said, no, this ain't right. You know, this has to be fixed.
Right.
So I threw myself out there like, okay, Keith, you know, we need to do something about this.
Now, I think you mentioned before, Keith, that at one time, UPS basically said, if this can go away, we'd be willing to give Francisco more money, more compensation?
No doubt about it. They made it known almost from the start that if Francisco would just go away, they had money to make him go away. In addition to the workers' compensation claim, Steve, we filed an action in the district court that if we could prove that workers' compensation no longer applied, didn't provide him with an adequate remedy, then we sued UPS in district court just as if there was no work comp system. So UPS, they were kind of panicked over that. So they wanted Francisco gone. They just wanted to pay him. They didn't want to see the whole card here.
Yeah, and Keith said that you turned that down on his advice.
And his advice, I did turn it down, but as well, I was like, you know, again, it comes back to the Kansas people. I was like, I'm not doing it just for myself.
Yeah, well, that's very admirable of you because, you know, obviously you were hurting financially.
Yes, I was.
Yeah, and you still went ahead, and it was for the Kansas worker.
It's Kansas worker. So, you know.
So what do you think about the justice system now?
It was great. When I heard the Court of Appeals come back with that decision, I was like, oh, nice. I was a little bit shocked when I heard the news from Keith.
Do your fellow workers understand what you did?
Yes, they do. They do. Now they do.
Yeah.
Now they
You explained it to
explained it, the whole story to them.
Yeah.
And what happened.
How does UPS think about you now?
I was on a thin line with UPS.
Yeah. Seriously?
Yes, I was. My job was on the line. They were constantly harassing me.
They were looking for a reason to get rid of you.
Get rid of me, just out.
How about now?
Now I don't get harassed. They leave me alone.
You're dangerous.
Don't bother with Francisco.
You're on national TV right now. What do you want to tell Kansas worker about your experience and the protection they have right now?
I want to tell the Kansas workers, don't be afraid to step up. If it takes all hard, go out there. If you know that it's right in your heart, do it. Don't do it just for yourself. Do it for other people. You get hurt, your family's going to be hurting. Just do it for yourself and the Kansas people.
Great. I want to thank you for being on the show.
Thank you very much.
Let's talk about workers' compensation. What does that mean to a worker?
Well, first of all, people that are on the job ought to have some protections. And so the law provides safety requirements, but unfortunately accidents happen. If you get hurt on the job, you get 3 benefits in work comp. You get your medical paid for by the employer. You get paid lost time, which is significantly capped in Kansas.
What's it significantly capped to?
What's $645 now?
No matter what you make?
No matter what you make. So if you're a $2,000 a week, a $1,500 a week, a $1,200 a week individual, you get capped at $645. Kansas has the strictest caps in work comp across the country. If you fall off a roof, Steve, you're a 25-year-old guy with 3 little kids, and you're making $1,200 a week, Kansas caps your permanent total disability, paralyzed from the neck down, never work again, at, wait for it, $155,000. That's what you get for the rest of your life for your permanent total disability. So,
and in other states, you would get, you tell them, Keith, it would be, you might get 4 times that amount, 10 times that.
Well, 2/3 of your wage. Take our sister state right across the river in Missouri. You get 2/3 of your average weekly wage up to like $950 per week for life. So you get your bills paid, you get your weekly compensation while you're off of work, and then you get your permanent injury compensation. In Francisco's case, he injured his shoulder. You're awarded X amount of dollars.
How do you feel about that cap, Kris?
I think the cap is unreasonable. You have to give the worker the fair value of what he lost, right? So if you, to use Keith's example, if a worker's in a wheelchair for the rest of his life and is in a situation where there are very, very few jobs he can do, and certainly the job that he trained to do and was planning on doing for the rest of his life is no longer available to him, putting that cap at $155,000 doesn't make sense if you're talking about someone who's going to lose 40 years of work, and the value of the work he cannot do for 40 years is a lot more than $155,000. So, I think ultimately, I think everybody would agree on this. We want the amount of compensation to be fair, and it should reflect the severity of the injury, and it should reflect the actual loss of working ability that the worker now has for the rest of his life.
See, and the way I like Kris' approach to this is fair. You notice how many times he uses the word fair. A lot of times, and you'll hear this argument in work comp, oh, the pendulum swung too far towards the worker and they're getting paid when they're not hurt and so on and so forth. And then in Kansas, the pendulum has swung so far on the other side that you have significant injuries where you get nothing. And so me, the Democrat, Kris, the Republican, can both agree that we need to have this equation solved in the fair range.
Right. And
fair to the employers, but fair to the workers.
And that's why the whole work comp system was created as a quid pro quo that both sides wanted. The employers wanted work comp a century ago all across America because they faced a risk of an unfair award by a jury that was maybe motivated by a very clever attorney to give an award that was a jackpot, that was out of proportion to the injury. And so the employer said, hey, we want a system where we have a schedule, we have a list of what the approximate injuries amounts are going to be, and I'm not going to lose a business if I'm an employer because one guy had an accident on the job. And then from the employee's perspective, there's the uncertainty of having to sue your employer. There's the uncertainty of not knowing what's going to happen in court if you bring that lawsuit. Why not just have a quick and informal system of awarding a fair amount? And so that's why both sides came together and said, let's have workers' comp. And it's worked very well for most states for more than a century. It's just that in Kansas here, we got to a situation where it was already very heavily tilted toward the employer, and then this last straw that broke the camel's back was going to the 6th edition, where it took some compensation down to 0, and that's unconstitutional.
You primarily represent union workers.
True.
Okay, so what do you want union workers to know about this decision? Because this is important. Well, this is the reason we're doing this show.
First of all, I want the union workers to know that Francisco Pardo was an absolute hero, because UPS wanted to pay Francisco more than this case was worth. But Francisco knew that this decision would have a broader impact on his brother and sister union members, so he didn't settle. He allowed us to take this case all the way through to prove that this is wrong, this is unconstitutional. So first of all, I want those union folks to know what a hero Francisco is. Number two, I really want my union friends to understand how hard that this conservative Republican gubernatorial candidate worked for them. That he didn't care what the party lines were going to be. He only wanted what is fair. And that's what I really want those blue-collar workers to know, that Kris Kobach went in the trenches to his own political detriment to make this right for my guys.
And I respect that a lot. And that's the reason we're here. I want to thank both of you for being on the show.
Thank you.
Thanks.
Thanks for joining us. You can get more information about our guest and the issues at insiderexclusive.com.